Good afternoon. Today I'm going to discuss an interesting case in the New South Wales Court of Appeal. Mamo, M-A-M-O, and Surace, S-U-R-A-C-E, 2014 NSWCA 58, which is a case which looks in detail at the way in which liability arises for what's called negligence in relation to a motor car accident. And so it's a pretty bread and butter sort of topic, but quite an interesting one. And judgment is given by Justice McColl, Ruth McColl, with Justices Ward and Tobias agreeing. And the facts were pretty straightforward. The driver is driving on a country road, semi-rural sort of road. He's got his lights on. Of course, he's travelling at a reasonable speed. And out of left field wanders a cow, with which he collides, unfortunately, and that causes some damage to his passenger, and that passenger then sues him for negligence. So a pretty straightforward textbook sort of question, perhaps an exam question. What happens if you're driving along a road, you've got your lights on, you're driving with due care and attention, a cow wanders out and it hits you, or you hit it, I suppose. Now, one complicating factor was this, that there was some evidence, although perhaps not as detailed as it could have been, which looked at how long the driver was looking at the road, and it would appear that, as with most of us who were driving, from time to time he looked down, and he was looking down either at a CD or radio or doing something or other, and then looked up, and that's when the cow arrived, so to speak. Question whether that involves negligence per se, I suppose, and whether or not you're meant to avoid all risk when you're on the road. Well, Justice Delaney in the District Court said no, there's no liability there, nothing you could have done to prevent the accident occurring, and the Court of Appeal, Justice McColl, with giving the main judgment, agreed with that decision. And the main point of the judgment, I guess, is from paragraph 48 onwards, looking in detail at the Civil Liability Act, which is an interesting piece of legislation, of course, because it doesn't, as Justice McColl points out, deal with the concept of duty of care and negligence per se. Funny thing, you'd think the Civil Liability Act would have a definition somewhere in it, but it doesn't. And as she says, as Her Honour says at paragraph 48, in this respect the heading duty of care in Division 2, which contains of course sections 5 capital B and 5C, appear that is apt to mislead. And that follows from what the High Court said in Adil's, Palace and Mubarak relating case. So accordingly, the identification of the duty of care, which the respondent owed to the appellant, that's to say the driver to the passenger, had to be determined by reference to common law principles. What are those principles? Well, the question of whether there's a duty of care, and if so whether it's breached, had to be determined prospectively. So it's prospective, you can't reason looking back in hindsight, looking back in anger. And the High Court has told us that in the case of Berry, B-A-I-R-Y and Wyong Shire Council, which is in 2005, High Court of Australia 62. Or if you've still got some old law reports on your wall, 223 CLR 422 at paragraph 126 and following, per Justice Ken Hayne. So, the court must not focus exclusively upon the particular way in which the accident that has happened came about, as to do so may obscure the nature of the questions presented in connection with the inquiry into breach of duty. So you don't just look back, as I said, in hindsight, you don't look at how it exclusively occurred, you look at the whole picture. And section 5 capital B1 of the Civil Liability Act sets out 3 preconditions that must coexist to establish a breach of duty. What's the effect of the section? Well, as Her Honour says at paragraph 50, the effect of 5B1 is that the respondent was not negligent in failing to take precautions against a risk of harm unless the risk was one of which he knew or ought to have known. So you've got to either know about the risk or ought to know about it. The risk was not insignificant, and in the circumstances a reasonable person would have taken those precautions. So unless you satisfy those 3 preconditions, you're not going to get up. Section 5 capital B1C looks at the notion of foreseeability as it's relevant to a breach of duty of care. However, reasonable foreseeability of the class of injury the plaintiff suffered is also an essential condition of the existence of the duty to take care for the benefit of another. And the nature of the foreseeability inquiry differs depending upon the stage at which it is being considered. 5B2 provides a non-exhaustive list of factors the court is required to take into account in deciding whether the third of those preconditions exists. So you've got that as a starting point. The inquiry as to duty or no duty addresses the foreseeability of harm resulting to the plaintiff from the conduct considered quite generally, according to Shirt and Wyong Shire Council. Our 1978 case, Justice Harold Glass. The inquiry as to breach involves identifying with some precision what a reasonable person in the position of the defendant would do by way of response to the reasonably foreseeable risk. We won't look at the citations, but you can see Justice McCullough 52. The principles concerning the duty of a driver of motor car to other road users and implicitly to passengers, and those pertaining to breach of duty by reference to 5B of the Civil Liability Act, have been considered, and Her Honour endorses what Justice Tony Marr said in Marion, M-A-R-I-E-N, and Gardner, G-A-R-D-I-N-E-R, 2013, New South Wales Court of Appeal 396, at paragraph 33 and following. And this is what Justice Marr tells us. The duty of a driver of a motor vehicle who uses the roadway, including pedestrians, is to take reasonable care for their safety, having regard to all the circumstances of the case. Under the common law, the standard by which reasonable care is measured is an objective and impersonal one. Alright. The question whether there's been a breach of that duty is to be addressed prospectively and by reference to what a reasonable driver in the appellant's circumstances would have done, if anything, in response to foreseeable risks of injury or sources of danger. This is the key point. A person is not negligent in failing to take precautions against a risk of harm unless the risk was foreseeable, not insignificant, and a reasonable person would have taken those precautions. Paragraph 35. Whether reasonable care has been exercised is not determined by asking if different conduct would have produced a different outcome and avoided a collision or accident. The exercise of reasonable care requires reasonable attention to all that is happening on and near the roadway that may present a source of danger. That in turn requires simultaneous attention to and consideration of a number of different features of what is already or may later come ahead of the vehicle's path. But, of course, the driver is not required to know or predict every event which happens in the vicinity of the vehicle, so as to be able to take reasonable steps to react to such events. The driver is only required to take reasonable steps to be in a position to know what is happening or might happen in the vicinity of the vehicle. Nor is the driver required to be in a position where he or she can react to everything which may happen in the vicinity. The driver is not required to travel at a speed which is within the limits of visibility and control, so as to be able to react to whatever ventures into the vehicle's path. And got some older cases. We've got Derek and Churn, where unfortunately an unattended child emerges between two parked cars, darts into the path of the vehicle. Driver is not negligent despite the fact that he was travelling at a speed which did not enable him, upon seeing the child, to avoid the collision. So essentially, I suppose it's a balancing act, so much as these days. Everyone who drives a car knows that you're travelling at 40 or 50 kilometres an hour, you're going to cover a lot of distance in 2 or 3 seconds. So unless you're going to walk along with a man with a red flag in front at 5 miles an hour, there will be certain events which you may be able to foresee as possible, but of course which you can't guard against. I suppose examples of other people, well, like an unfortunate example, a child darting out from the roadway chasing something, perhaps a dog running onto the road, another vehicle suddenly changing lanes and coming across into your path, things like that. Those are all things which everyone who's driven a motor car knows can happen, but which is very difficult to guard against. And in fact, you're not negligent if you don't. So, as Justice McCullough says, it was uncontroversial that the respondent owed the appellant a duty to take reasonable care. In some cases, even as no issues to the duty being owed, there will be a debate as to what the duty required, for it's only when the content of the scope is identified that the questions of breach and causation can be considered. However, in considering the scope, extent of duty of care in a simple case, the motorist and injured road user, the content issue is adequately addressed by identifying the kind of damage suffered and the class of which the plaintiff was a member. Circumstances of the case, time pro and judge took into account the duty of content of care ought not to have referred to what the respondent knew or ought to have known immediately prior to the accident, but Her Honour said that wasn't a material error. The effect, paragraph 59 of His Honour's decisions, was in my view that having regard to the low risk of encountering the other object on the road at the hour and in the area the respondent was driving, it was not a breach of duty for the respondent to take his attention off the road. It was a sort of activity which was inherent in driving a motor vehicle and might have been engaged in the circumstances in which the respondent was driving by any reasonable driver in his position. And Her Honour accepts, paragraph 60, that the exercise of reasonable care required the respondent to be able to control the vehicle so as to know what is happening in the vicinity of the vehicle to take reasonable steps. And that does not, however, require the reasonable driver to be able in effect to foresee every event which might happen in the vicinity of the vehicle. In short, paragraph 61, the driver may be found not to have breached his or her duty in every circumstance where he or she collides with an object on the road. There will be circumstances in which there's no breach of duty, but there is in effect an unavoidable accident. And here, that's really what happened. The appellant didn't contend there was too much speed, within the speed limit. There was a question of paying attention to the road, but it didn't appear that there was much evidence in relation to that. It wasn't clear how long the driver had looked away from the roadway. So in all the circumstances, on that particular aspect, the appeal was dismissed. And we've also got the Motor Accidents Compensation Act and the notion of a blameless accident. Interesting, isn't it? A blameless accident case, but for whatever reason that doesn't seem to have been run at trial, and this judgment is interesting because it does discuss by way of dicta how the Motor Accident Compensation Act might apply, but in this case it wasn't actually attracted. So a short case, an interesting one I suppose. If you're practising in the tort area, it's always good to get something which tells you synoptically what's going to happen. Of course, in almost all these cases we're looking very closely at the facts and situations, change circumstances. I guess if you look away from the road for 20 or 30 seconds and you run into something, it won't help you. But an inadvertent glancing down to the speedometer, or to check the radio, or to check something else, or to check your rear view mirror, you can't have eyes everywhere in that sort of situation. If something leaps out, a kangaroo or a cow, I'd say it's nothing more serious, but if something leaps out at you, then it'll be almost impossible to react. So have a look at the case. Interesting, short one, but very useful for anyone practicing in the tort law area.